All right, we're just going to give it another minute or so to let folks join. We're just giving it another minute or so to let people join. All right, let's get started. Welcome, everybody. My name is Robin Gross, and I'm the policy chair of the San Francisco Bay Area Internet Society. It is my pleasure to welcome you to this edition of our chapter's monthly tech policy webinar series, which can all be seen on our YouTube channel. Today's topic is on a new internet censorship law, specifically the state of Florida's attempt to regulate online speech and a lawsuit winding its way up the courts that is sure to set important legal precedent on the application of the First Amendment on the internet and the ability of states to regulate social media platforms. The Florida state law at issue was passed after the former US president was kicked off from social media platforms, including Twitter, Facebook, and YouTube, in January of 2021 during the final days of his term. Florida's governor and state legislature responded to that deplatforming by passing a state law that made it illegal for social media platforms to ban politicians. The Florida law, SB 7072, also made it illegal for platforms to moderate the content posted by politicians to their sites. The new Florida state law raised numerous concerns from First Amendment organizations, as well as internet companies concerned about its impact on online free expression and innovation. As SB 7072 was about to go into effect this past summer, a lawsuit was filed against the state of Florida to challenge the new law and prevent it from going into effect. The lawsuit was filed by two nonprofit organizations who represent the interests of internet companies, NetChoice and the Computer and Communications Industry Association, or CCIA. NetChoice and CCIA asked the court to invalidate the state law and prevent it from taking effect on the grounds that the law amounts to an unconstitutional violation of the free expression rights of digital platforms and internet users. The new law, they said, violates the First Amendment rights of internet companies by compelling them to host even highly objectionable content that is not appropriate for all viewers, or violates their terms of service, or conflicts with the company's policies and beliefs. The lawsuit also said that SB 7072 is a violation of the Equal Protection Clause of the Constitution, since it specifically exempted large Florida theme parks, Universal Studios, and Disney, treating citizens differently. The case also invoked Section 230 of the Communications Decency Act, a federal law which also protects the company's right to moderate their platforms and which preempts states from regulating such conduct. In June of this year, the district court judge in the case agreed with NetChoice and CCIA and issued a preliminary injunction against SB 7072 from taking effect on the grounds that it is unconstitutional under the First Amendment and preempted by federal law, Section 230. The state of Florida appealed that ruling to the 11th Circuit Court of Appeals, where the case is currently pending and being briefed. Whichever side loses at the 11th Circuit will likely appeal that ruling to the US Supreme Court. The case is likely to set important precedent for internet censorship and technological innovation and is one to watch in the coming months. A wide range of amici curiae filed legal briefs with the court, providing further argument against the Florida censorship law including industry organizations such as the Internet Association and the Chamber of Progress, as well as civil liberties groups such as the ACLU, the EFF, and the Reporters Committee for Freedom of the Press. We are fortunate to have with us today to discuss the case one of the authors of an amicus brief filed in the case, Elizabeth Banker, who is also a leading tech policy expert on Section 230. Elizabeth Banker serves as the Vice President of Legal Advocacy for the Chamber of Progress, a new tech industry coalition devoted to a progressive society, economy, workforce, and consumer climate. The Chamber of Progress's mission is to support public policies that will build a fairer, more inclusive country in which all people benefit from technological leaps. Previously, Elizabeth served as the Deputy General Counsel at the Internet Association, where she focused on data privacy, security, and intermediary liability issues. Last year, Elizabeth published a report that analyzed over 500 Section 230 legal cases brought over the last 20 years, and which made a number of key findings and insights to help us think about 230. Elizabeth has advised Yahoo and Twitter on law and policy over the years. She lives here in the San Francisco Bay Area, earned her law degree from the Catholic University of America, and earned both a bachelor's and master's degree in philosophy. Elizabeth will talk for about 30 minutes, followed by taking questions from attendees. We ask that you use the Q&A feature to ask questions throughout the presentation, and we'll collate your questions and get them answered in the last 20 minutes of the webinar. And with that as background, let's jump right into the discussion. Elizabeth, over to you.
Great, thanks so much, Robin, and thanks for having me back. It's a pleasure to be back talking to you guys, especially about this important issue, which, as you explained very well, really does have a tremendous potential impact on how online services attempt to make their services safer for consumers. And so with that, I am going to show a few slides, so just bear with me for a second while I share my screen, and we can get those rolling. Great. Oops. Not the screen I want. There we go. All right. Well, thanks to everyone's patience for my technical deficiencies. But we use a different platform to do video for every single call these days, right? Well, you know, I was really happy to come talk about 7072 in Florida and the NetChoice v. Moody decision. It's actually one that Chamber of Progress filed an amicus brief in on the district court level, because we were so concerned about the impact that the bill would primarily have for consumers. But to really explain that impact, I feel like I need to back up and maybe start with some additional context for you about these types of bills and what's been going on around the country in 2021, more details on this specific bill, and on the legal arguments that are going to be put in front of the 11th Circuit in connection with the appeal. And then finally, we can talk about, you know, really how that impacts the businesses as well as the people who use services. So Robin gave you some really great context, so I don't need to repeat that. But I do want to emphasize that you know, this activity in 2021 was part of a really big push that really went across the country. So it wasn't just Florida reacting with legislation like this. You know, Republicans, conservatives in 30 plus states introduced bills that were in some senses similar to the Florida bill, now law. Utah was actually the first to pass a law like this, but the tech industry in Utah was able to explain what the problems with that legislation actually were, and the governor did veto it with kind of the expectation that all the parties would come to the table and talk about a better approach. Florida was the next one to pass. And we'll go through the time frame there, but it was very quickly enjoined from going into effect. But that had absolutely no bearing on Texas's decision to do similar legislation. And so they passed Texas House Bill 20, which has some similar aspects to Florida, but is also a little bit different. And we can get into that later. But that bill is also being challenged now, and that is at the district court level. So these bills, as I say, they have things in common, but they're also a little bit different. The types of things they have in common are, the objective is to try and prohibit or at least impede to a certain extent what is being called viewpoint discrimination. Viewpoint discrimination, if you're familiar with First Amendment case law, is kind of a loaded term to use when it comes to private companies, because viewpoint discrimination is something that the government's not allowed to do under the First Amendment. But we'll talk about how that applies to private companies in a little more detail in a minute. But the different ways that the states are trying to attack this relate to things like putting in place disclosure requirements that are burdensome or involve revealing proprietary information, such as cataloging all of the algorithms that platforms use related to content and content moderation, regulating the removal process, whether it's in terms of providing notice, responding to complaints in a certain manner, appeals, and then prohibitions on content moderation. And this is kind of where Florida and Texas are a little bit different. So maybe I'll just start with Texas, which basically prohibited providers taking any action on content that was based on a viewpoint being expressed in the content, which, obviously, most content tends to reflect a view of the person who posts it. So, it's a rather kind of sweeping ban, and that's a major issue in that litigation. But in terms of Florida, I think it's probably easiest just to start at the beginning and explain everything that's in there. So we'll start with who does it apply to? Well, the answer is, in the language of the law itself, it says social media platforms. However, how that is defined is very, very different. It's very broad. Information services, search engines, access software providers. So, it's really a broad range. And the limiting factor in terms of who's covered and who isn't are these thresholds that Florida put in place. So platforms that have 100 million global users are covered. And just one note there, a quick Wikipedia search turns up, just for social media platforms, that there are at least 32 in the world that have at least 100 million members. So even if you're thinking about social media companies as what's being covered, it's still not what most people associate with big tech. And then the other measure is 100 million in gross revenue annually. So those are kind of the contours, except there's one extra piece, which is if you meet those standards, but you own a theme park or entertainment complex, then you are exempt. And this was a kind of a last minute political compromise related to some theme parks that operate in Florida, and are important constituents. So we've got that provision. So next, let's talk about what the law regulates. I'm referring to it broadly as content moderation, by which I mean not only decisions about what to remove or what actions you take on an account, but also all of the different tools that come into play when providers are thinking about how to expose the most valuable and highest quality content to users, and kind of make sure that the things that are potentially suspicious, seem kind of spammy, or just generally low quality, don't make it to the top. So it's broad. So Florida picked 3 terms and defined them. I think when you look at the terms and their definitions, you can see how broad it is. So censorship is one of the things that is prohibited, or at least regulated. And it doesn't just mean removing, editing, altering. It means limiting republication. So that could be a retweet, giving an account a timeout from being able to post, restricting an account from interacting with another user, which could actually implicate certain safety tools that platforms have, like muting and blocking, and posting any type of addendum to a piece of content. So this could be an interstitial warning for explicit content. It could be fact checking. It could be surfacing authoritative information next to content, or labeling something like state-controlled media, for example. So the law also regulates shadow bans. Shadow bans are defined as any action taken to limit exposure of content. So, obviously that could be something that happens in response to a determination that certain content may violate the rules or is extremely likely to violate rules, but it could also be swept up in any number of the more types of quality controls that I was talking about in the products. And post prioritization is also another regulated activity, and that's placing content either ahead of or below other content. So it really captures all decisions about content placement on a platform. So let's talk about how this operates. There are really kind of strong restrictions on moderating content that is posted by candidates for elected office, particularly during the actual campaign cycle. And really, in terms of removing content or removing an account, there are no exceptions that specifically apply there. So really only, anything that's a federal crime would really be the exception there. Now, journalistic enterprises, which is also a defined term, are also protected from content moderation. This is really interesting because journalistic enterprises, which many of you may hear that and think about newspapers or broadcast news networks that are online, that's not actually strictly how it's defined. One of the key parts of the definition of journalistic enterprises, rather than focusing on anything that's unique to the activity of journalism, instead focuses on how much content the service posts and how many users they have. And so if a platform, like Netflix, they actually post the majority of the content. So, they would fall under this. But, it also is very interesting because, potentially a site like Pornhub could also fall under the definition of journalistic enterprises. And so this protection from content moderation could have fairly sweeping consequences for services that don't allow adult content. So in addition to those restrictions, there are also requirements on a number of different aspects related to content moderation. So providers have to post their rules, provide users with advance notice of changes, and they are actually prohibited from changing their rules more than once a month. And this is important because providers, while they tend to think, very carefully about every potential type of abuse that could happen on their networks, I think we've all seen over the years that things emerge that really just no one ever thought someone would do, and there's a need to respond. And so, there could be potential ramifications for this type of thing. If, let's say a relatively small provider in the grand scheme that does meet the requirements, didn't think about things like the Tide Pod Challenge, but are very, they're very worried about the impact it might have on teens, that if this thing is going viral, and that people could actually get hurt. This would actually prevent them from, creating a new rule or clarifying a rule to sweep in that additional content. The law also requires notice of censorship and shadow banning. And so this is notice to users. These notices must contain thorough explanations of the violation, as well as a description of how the provider detected the violation. And so, this is concerning for several reasons. One, providers don't want to reveal how they detect violations because bad actors are very able to use that information to try and evade detection. But also, providers are literally removing billions of pieces of spam a year. For Facebook, it's billions a quarter. And, not every action actually triggers, the company's notice policy today. But this would change it so that every time there is an action that would be considered censorship or shadow banning, the provider would need to provide notice and would have to provide these additional explanations, which essentially creates a huge burden and makes content moderation more difficult and expensive. So another requirement on the same theme of transparency is providing notice regarding all the algorithms that are in use related to content on a platform and how it gets placed and whether determinations regarding whether or not it violates rules. In addition to these annual disclosures about algorithms, providers who are covered are required to give users an ability to opt out of any type of content placement related algorithm so that they can see content either chronologically, alphabetically, some method other than the proprietary algorithm that a provider might use. So that requires some significant product changes. But it's this last one that's kind of like the real problem here. And it is this idea of a requirement that providers are consistent in content moderation. And I'll talk in more detail about some of the issues around this, but I would just say now that consistency isn't defined. And so it could be interpreted in some different ways, but it's not clear that it requires a provider to basically be perfect and find every potential violation of similar nature when they're looking at a reported violation in front of them and they're about to take action. And we'll talk about the liability piece, but I think with the specter of private lawsuits with large damages, providers would obviously think about that rather carefully. So as I mentioned, the bill is enforced through a private right of action. So only 2 of the provisions are subject to the private right of action. That is the notice requirement and the consistency requirement. And users who prevail will at minimum get $100,000 in statutory damages, but they're also potentially entitled to actual damages and then punitive damages. And then for the whole of the bill, it's something that the AG can enforce. So I will, I have to say, that was an overview. It was not comprehensive. There are a lot of different aspects to the bill. So there's a big antitrust section that I didn't talk about, but is part of the lawsuit, because I really just wanted to focus on the content moderation pieces. So as Robin said, this all happened really quickly. And luckily the preliminary injunction was entered before the bill went into effect. But I would just focus here maybe on looking at the span of time between when the bill was introduced. And yes, it was on April 1st, no jokes about that. But it was actually passed by the end of April. And this is a really important thing to point out about the states and how this activity happens, because it happens very quickly. And sometimes, the policy response just doesn't have enough time, or really, I think arguments that are winning, with the proponents of these bills, which makes the legal advocacy side even more important. So I will now jump into the key arguments that are at issue and what's going to be in front of the 11th Circuit. And this is really a First Amendment case. For those of you who don't have a ton of familiarity with the First Amendment, maybe just a little bit of background on that for you. As I said earlier, the First Amendment applies to governments and, with only a few limited exceptions to private parties. And so, the amendment says Congress shall make no law. So there is this state action requirement for there to be a violation of the First Amendment. That's something that comes up, when people, for example, sue providers arguing that the provider violated the user's First Amendment rights by removing their content or taking down their account. Which is somewhat similar to what's going on in former President Trump's lawsuits against Facebook, Twitter, and YouTube. Another thing to know about the First Amendment is that companies, so online providers, do have First Amendment rights like individuals, and that First Amendment rights apply not just to the expression of what you want to say, but it also protects the right not to say something. And so this is really important in this case, that protection extends to the ability to refuse content, to take it down after it's been posted. So what the companies are arguing in the lawsuit is that in many different ways, 7072 is violating their expressive rights by restricting what they can do. So, for example, they are not allowed to rank and order things without restriction the way they would like to, particularly when it comes to political candidates and journalistic enterprises. There's also an element of compelled speech that is part of the law. So not only are they being forced to carry content that they wouldn't otherwise and may not agree with, but they're also being forced to say things that potentially against their interests, such as sharing information about how their detection mechanisms work. In addition, they are prevented from speaking. And so, we see this in the restriction on updating the rules for the platform with that limit to every 30 days. We also see it in the definition of censorship, which includes that labeling or adding addenda or context around content. Since providers are restricted on doing that, that is itself kind of a restraint on the speech they would like to make. In addition, viewpoint discrimination under the First Amendment is definitely problematic. There is an argument here that the whole law is essentially retaliation for a point of view that the companies have been expressing through their decisions about what content to moderate. In fact, the fact that proponents of this type of legislation are responding to what they call conservative bias, it does suggest that the fact that these platforms are liberal in their view is actually something that they're trying to punish them for and restrain them from expressing. We also have discrimination based on speakers. So obviously things like the theme park exception and the numeric thresholds, the special treatment for journalistic enterprises, those are all things that the government has to justify. I also mentioned previously that there are some really key missing definitions, such as what is meant by consistency. So we have a vagueness issue. So the state's response, and they just filed their opening brief not that long ago. So they are basically saying there's nothing to see here. They're saying this is all normal. This is, really consistent with other situations where the government has been able to require private actors to do certain things. And so one of the ways they're responding is by calling the entire law a set of hosting regulations that they say are completely consistent with the First Amendment. And they rely heavily on a case called Rumsfeld v. Fair. And that case had to do with military recruiters and their access to on-campus recruiting events at law schools, private law schools that took federal funds. And in that case, the Supreme Court decided that this question of access wasn't about speech, it was about conduct. And so it allowed the federal requirement that gave military recruiters access to these recruiting events to stand, and decided it was consistent with the First Amendment. There are some different things going on here, though. So first of all, this all has to do with expression. So it's very different than the Rumsfeld v. Fair case in that way. But also, and the state makes a big deal about the ability of a provider, much like, the law schools in Fair, to use speech as a way to distance themselves, to make sure that, the public doesn't think that this is actually their speech. What they fail to mention when they discuss that is that they actually prohibit that speech in the form of the restriction on adding labels and fact checking and addenda around user content. So that's kind of one piece of this. The next piece is this idea of common carriers. And common carriers kind of has been a magic term over the last maybe year or so, where it's kind of assumed that if you can declare a private company a common carrier, that at that point they have no rights, and that's not quite true. Regulated utilities certainly do have some obligations, but the First Amendment in the telecommunication space has never said the First Amendment doesn't apply. Instead, they have upheld and rejected certain restrictions kind of based on things like the scarcity of bandwidth or licensed spectrum, and decided that gave them a measure of ability to do more regulation. And finally, there's this idea that regulatory disclosures are normal. Lots of businesses have mandatory disclosures that they have to do. Pharmacies have to publish drug prices, tobacco purveyors have to put warnings on, and that the items of compelled speech here are just like that. But what is different is that kind of the content and the fact that this relates to expressive activity. All right, so 230, section 230 is also a piece of this. Industry is arguing that section 230 protects all content moderation. Broad protection for both keeping content up, making decisions about how to order or rank content, as well as decisions about removing accounts and actual content. So section 230 has an exception that allows states to enforce their own laws without being barred by section 230, as long as it is consistent with federal law. So the argument here from industry is that 7072 just in full conflicts with section 230 because it attempts to regulate content moderation, and the providers can't be held liable for their content moderation activities. The state is trying to make this about an interpretation issue related to C1 and C2 that maybe I'll save dipping into that if there are any questions, but basically they want to take a very narrow reading of section 230 and say only the protections for removing content that are in 230 C2A apply, and those protections only apply to things like good faith removals. And they're saying that section 230 doesn't preempt because if a provider does not act with good faith when they moderate the content, that is something the state would be able to regulate. They're also saying that things like deplatforming users, that's not removal of content, so it doesn't fall under that protection in section 230. So there are definitely some interesting arguments happening there. I did put in a bit on the Commerce Clause. This isn't necessarily going to be an issue in the appeal, but there are some very interesting jurisdictional issues related to the Florida law because it protects the right of Floridians to receive content. And so it has potentially really broad jurisdictional sweep. So Now I think, want to get into the impact on business and consumers. So maybe it's just starting with business, because I think it informs the impact on consumers really well. So there's a lot of concern that, 7072 is going to force providers to change fundamental parts of the product. So this ability to opt out of the ranking algorithms, for example, requires kind of building new functionality into sites. There is concern, as I mentioned earlier, that because there are certain user-directed safety tools like mute and block that are implemented by providers, that those could be at risk, and providers will have to figure out the potential liability issues related to using those, because they do interfere with how different users can interact with each other, which is part of censorship. Because of the definition of journalistic enterprises, as I mentioned, there's a real potential that certain sites that maybe have explicit material, or certain foreign actors who are engaged in disinformation campaigns may have kind of this free pass, and that places like kid-friendly sites don't have any exemption that would allow them to maintain kind of their healthy environment and enforce the rules. Obviously, talking about how all of this operates, it's probably very clear to you that there are going to be a bunch of new costs, in addition to the actual explicit limitations on content moderation. I already talked about notices, and the burden associated with that. But there are a couple of other things worth pointing out. Every action that content moderators take regarding content is going to have to be looked at with the lens of who is the speaker, do they fall in one of these protected categories, and also this issue of consistency. And I think it's reasonable to say that given the damages, that providers may actually try and narrow their content moderation efforts to only the worst of the worst, to make sure that they can do everything they're required to do, and to limit that liability risk. And of course, there are a lot of issues that could blow back on companies, but this issue about disclosures, obviously, you don't want to give spammers a leg up ever, or scammers or phishers, or any number of the bad actors out there that have a real financial incentive to constantly match the efforts that providers take to try and detect activity and to keep it off their networks. So even, if there are billions of items of spam, even if you don't think that's the companies do a great job at it, even a very small percentage of that being able to evade detection really worsens the experience for consumers, and that also has costs for the platform. Now, the impact on consumers, by now you probably have lots of ideas about how this could go, but really what we're concerned about is it just seems likely that users, as they go about their daily business, are going to have to wade through a whole bunch more just kind of what we call lawful but awful content. So things that don't violate federal law, which is really the only exception. But people don't want to see. And, so not to harp on spam, but, one example of that is that companies have their own definitions of what's spam that's much different than federal law or the Florida spam law, and much broader. And so to the extent they're limited in their ability to deal with that, we're going to see more of it. Hate speech, Holocaust denial are clear examples. There are certain things that some states and the federal government don't yet have laws on, like posting non-consensual intimate images. And so, for many people, particularly those that are going to be targeted by that type of harassment, the online experience becomes much, much worse. Impact on child-friendly services, fewer safety tools, less context around content. And really, I think we could see, if these laws take off, a real movement towards looking at these alternative approaches to enhancing safety. For example, recently in the kind of the public discourse about these issues, there's been a lot of talk about whether or not users should be required to verify their identity to use social media and other services. And that's certainly something that sites could consider, as well as subscription-based or fee-based services, to try and weed out people who are bad actors. And really a movement away from user content to more focus on partners providing content that are known to be responsible, and where the need to moderate is less. So just finally, kind of what's next? So the 11th Circuit will be hearing this case. So we'll be looking for a decision from that. It's hard to say when. The federal district court in Texas will be looking at the preliminary injunction on that bill before it goes into effect, as scheduled on December 2. So we'll see if they take action about that. And then finally, we're watching the states. We think there are going to be a lot more bills like this. So happy to talk about questions.
Thank you very much, Elizabeth. While folks want to get their questions in either in the chat or the Q&A, or just raise your hand, I've got a couple questions in the meantime. One has to do with the freedom of association of internet users. And, that's an important First Amendment right as well. And it strikes me that another problem with this bill is that it doesn't allow internet users to sort of associate themselves in platforms that have certain terms of services that they're more comfortable with. Like you mentioned, people are going to be forced to look at hate speech. They're going to be forced to look at offensive speech. Their politicians aren't going to be able to be deplatformed. And so in a sense, it strikes me that this bill additionally creates a freedom of association issue of internet users, and their ability to create communities online that coincide with their own beliefs. Do you think that's a fair point?
I do, and I think it's really interesting, and I probably haven't thought through it quite enough, but certain platforms that are likely covered by this, such as Reddit, actually have a content moderation system that relies in large part on users of the systems to moderate their own content and set their own rules. And that is one of the ways that Reddit really accommodates the interest in having kind of these really unique communities where users come together because they want to associate together. Whether it's, to give each other support or because it's a shared interest they have. And it is not clear whether they would be able to continue to allow moderators of subreddits to enforce the rules however they want. And so I think that has huge impact. And, in terms of the legal case itself, Chamber of Progress is really interested in the impact on consumers, and we feel like it's really important to understanding the analysis that a court does regarding a preliminary injunction, as well as understanding the government interest in these First Amendment issues. But the lawsuit itself isn't about kind of vindicating user rights. And so, you know, I think it is important that the consumer voice is part of the overall discussion, because, you know, it's not kind of formally the rights of users being asserted in the legal case.
Thanks. I also had a question about the economic impact of this bill on the growing internet sector of the economy. I mean, US tech companies are some of the largest, fastest growing companies in the world. And this is in large part due to the immunities that Section 230 affords them. And so it kind of allows them to have some leeway for innovation. And so I'm wondering, what do you think about the overall economic impact on the internet sector, the US tech companies that this kind of a law can create?
Right. Well, it's really interesting. One of the issues I didn't get into very deeply is this the Commerce Clause issues. And as I said, though, this law does regulate interstate commerce. It also kind of regulates global commerce online, because there isn't a requirement that the user be in Florida, that is impacted by the censorship, because their interest in receiving content is sufficient to trigger the law. And so, it's so broad. I think there are a lot of important issues there, but just to get down to the kind of the practical realities of it, online services are already being sued for removing content. They do rely on Section 230. They get sued by, for removing vaccine misinformation, for removing, state-sponsored foreign influence campaigns, all sorts of things that maybe people don't realize. But this private right of action is going to incentivize that activity to just, multiply in ways that I think are going to be really damaging. And I think, maybe the big companies can weather that without it affecting their bottom line. But, the real concern is with this 100 million user and revenue threshold, we're talking about some fairly small companies. I mean, we're not just talking about Facebook, we're also talking about Pinterest. And so, not to mention the other companies that are kind of in the pipeline that are growing in popularity, like Discord, Clubhouse, and some others. So, the question is, what's the impact going to be on innovation? Are people going to want to go in this space? Are they going to develop new services? Or is this going to be something that kind of frightens people off?
Yeah, it seems like we might be killing the golden goose with bills like this. I had another question. In some of the briefings I've seen from the state of Florida, they're saying, well, if you're going to find any part of this law unconstitutional, then we have a severability clause, so it's just severs from the bill, and the rest of it will continue to be a good law. I'm wondering, do you think there is any part of this law that could successfully be severed through a severability clause and continue to go into effect after this ruling?
That is a really good question. I think that one of the things that wasn't done well in the briefing was actually identifying for the 11th Circuit what those pieces Florida thinks actually are. Because I think that the law is just really difficult. It has a lot of very complex pieces that work together. And I think isolating one piece of them is going to be difficult. But, Judge Hinkle, who is the district court judge, when he held the hearing on the preliminary injunction, he asked the state about this a lot because his concern was, are you going to look to me to rewrite this to make it constitutional? Because sometimes, if you're just striking out provisions like maybe the theme park exception, is he stepping into the place where the legislature really should be? And what happens when you start striking out pieces? And so I think it's asking too much of a court, just given the types of problems, how pervasive they are. And so, I would be surprised personally if a court decided to kind of pick and choose.
Yeah, that makes sense to me as well. Were there any surprises for you in the district court's ruling when it granted the injunction?
I think that one of the things that surprised me, going back to Section 230, Judge Hinkle, when he wrote the decision on the motion for preliminary injunction, he really didn't want to get into the controversy that exists over the interpretations of particularly whether the C1 protection that exists for online services that publish third-party information also applies to removing third-party information. And, there is unfortunately some bad precedent at the district court level in the 11th Circuit, that obviously he probably didn't want to take on. But the vast majority of courts, including federal appellate courts, have held that C1 does apply to decisions to remove or not to publish. And so, I feel like an opening was there. I understand why he might not want to court that controversy if he didn't have to. But I did think that the way he handled that was interesting.
Yes, yeah, it definitely was. Okay, does anyone else have any questions or any comments for our speaker today? We've got just a couple of minutes left. Well, I don't see any more, so I think then we can call this webinar to a close, and I must thank our guest, Elizabeth Banker, and the Chamber of Progress, and thanks to those of you who joined in today's session. It will be posted up to our YouTube channel later today for anyone to watch, and I hope you will consider joining the San Francisco Bay Area Internet Society chapter. You can go right to our website, sfbayisoc.org, to do that. And with that, I thank our speakers and thank you all. And I will call this to a close. Thank you.
Thanks, Robin.